everyone, Urvi this side. In today's video, I will be discussing about trespass to land. Trespass to land occurs when a person intentionally enters someone else's property without the permission. The only intent required for the claim is the intent to enter the property. So even if your neighbors accidentally cross from their property into your lot, they can be liable for the trespass. A trespass can also occur if someone causes a physical item like a golf ball to enter your property. Substantial injury is not required. Proving trespass to land claim. In order to prove that the defendant is liable for the trespass to land, you will typically have to show that four distinct actions occurred. Number 1 is the entry. The defendant must intend enter the land that is the subject of the trespass. It is not required that the defendants intended to do so wrongfully. So entering land by mistake can be a trespass in some states as well. Causing an object or thing to enter someone's property can also be considered as trespass. Second is property of another. A trespass claim must be brought by a person with a legal interest in the property, such as an owner or the tenant. Third, without owner's consent, entry onto the property must be unauthorized, either expressly or implied. For example, the police and the postal carriers has implied consent to be on the most residential property. So a trespass cause of action would fail in such cases. Fourth is the damages. In most cases, to establish a viable claim, some damage must be suffered. The defendant didn't need to intend to cause the harm, but the defendant's conduct must be a substantial factor in causing the harm suffered. The physical act of intrusion onto the land, even without the significant damages or harm, is typically enough to support a trespass claim. In some states, such as California, annoyance and discomfort are enough to establish trespass to land. What damages are available? A property owner or the tenant has the right to compensation for the injury caused by the trespass. Depending on the nature of the trespass, you may be able to recover the following damages: loss of the market value, cost of restoration, loss of use of the property, physical injury to the person or to the land, emotional distress, discomfort and annoyance. When permanent injury to real property occurs, the general measure of the damage is the loss of fair market value. In cases of temporary injury, the cost to repair or restore is the common basis for an award. However, when the cost to repair or restore exceeds the decrease in market value to such a degree that repairs are no longer economically feasible, then damages are awarded only for the loss of market value. Getting an injunction. Maybe you don't need compensation for damages, you just want the trespass to stop. An injunction is often the best way to stop repeated trespassing. Many state codes have forms to help you draft your request. Liability for injury to trespassers. Generally, a property owner or a tenant is not responsible for the injuries of a trespasser, but this doesn't mean the property owner owes no duty to a trespasser. The following are the situations where a trespasser can be held liable for damages suffered by someone not rightfully on your property. Discovered trespassers. When a landowner or tenant discovers or anticipates trespassers, they must warn or make safe concealed unsafe artificial conditions involving risk of death or serious bodily harm. You don't need to see the people who trespass to know of their presence. A path worn in the earth or trash left behind in a building is enough to make trespassers discovered. Thank you.